The Sunny Isles Beach City Advisory Committee presents What You Should Know About Condo Living, featuring guest speaker Lazaro Gonzalez from the Department of Business and Professional Regulations, Division of Condominium, Timeshares, and Mobile Homes, Bureau of Compliance.
Good evening. Thank you very much for attending, and I'd like to extend a warm welcome on behalf of the Citizens Advisory Committee of Sunny Isles Beach. My name is Dana Goldman. My colleague Howard Gordon also serves on the advisory committee, and I'd like to, of course, recognize our great mayor, Norman Edelcup, who's just finishing up his tenure and with great pride and great accomplishments for the city. Like to acknowledge our esteemed commissioners, Jeanette Gatto, who is by all means a unit owner, a condominium unit owner advocate, and our esteemed commissioner, Isaac Elian. And with that, I'd like to introduce our key speaker, and I'm particularly excited about bringing Lazaro Gonzalez here this evening to speak to all the unit owners and the respective condominiums in Sunny Isles, because Lazaro is an experienced educator, and he delivers seminars and training programs throughout the state of Florida. He is with the Bureau of Compliance, which is a subdivision of the Division of Florida Condominiums, Timeshares, and Mobile Homes through the Department of Business and Professional Regulation. And that's, of course, headquartered in Tallahassee, but Lazaro actually is here in Fort Lauderdale. And I think given his many years of experience training not only unit owners or educating unit owners, but also training condominium boards, officers, directors, managers, and so forth, he can bring to light some of the issues that affect all of us, as presumably all of us in the audience, we're all condominium unit owners. So this is clearly from the perspective of the unit owner in a condominium. What are your rights? What jurisdiction the Bureau of Compliance has, who to know, where to go, and so forth. And with that, I'd like to have Lazaro take the floor. Thank you very much.
Thank you, everybody. Good evening. As Ms. Goldman said, my name is Lazaro Gonzalez. I started with the Bureau doing investigations. So some of you I've known from your condominiums, because when I started, I did the Miami section mostly. I didn't do Fort Lauderdale, I did Miami and Monroe County. I started teaching about 2.5, 3 years ago, and it's been great. I travel, as Dana said, all over the state of Florida. We do have an office. Our office is in Commercial Boulevard, right off of 95. We have an open door policy where unit owners can come in and talk to an investigator personally about their issues, about their concerns, any allegations that they may have. They can absolutely come in, and I know some of you from your buildings have come into my office, so I'm familiar, with you guys coming in. We have offices in Orlando, Tampa, and Tallahassee, which is our main office. But we are the only office in the state that actually has an open door policy. Monday to Friday, 8 to 5, you can come in and talk to any investigator. We also have a financial department, investigators in the office in Fort Lauderdale that handles anything that has to do with a financial issue. Special assessments, budgets, operating funds, any situation like that, you can also talk to somebody that's knowledgeable in financials, okay? I was giving Ms. Goldman some information. There's approximately 1.5 million condominiums in the state of Florida, and 75% of those condominiums are in these 3 counties, Miami-Dade, Broward, and Palm Beach County. The rest of the state has a lot of HOAs and mobile homes and co-ops. We have some co-ops here still, but not as much. But the bulk, that 75%, is in these 3 counties. So as you can see, our office is pretty busy. We handle about 1,200 complaints a year. People come in, like I said, they send it in. We do a lot of situations. And I'll go into, before I go into this, to give you a little bit of what the divisions has jurisdiction to investigate. What I gave you guys is the actual updated 718 book, which is the Condominium Act. That's what governs your condominium along with your bylaws, declaration, and articles of incorporation. That's the newest version. Actually, combined with that is the administrative rules, which go hand in hand with the 718. So now, it used to be 2 books. Now we got them into 1. We kind of condensed it a little bit. So you guys got that. The other publication that I gave you has this presentation written on it, and it has a lot of other information about elections. It has a lot of information about record access. It has a complaint form in there, what it looks like if, you know, if need be, you need to file a complaint. It has some others, a couple of other things. Our websites, our phone numbers, and all of that information, it's on that second publication. So that's something that you guys can kind of reference quickly if it's something related to, like I said, elections or record access or any situation like that, okay? So having said that, what the division has, we originally, up to 2008, we had jurisdiction over everything in that book. Statutes change, legislatives change at that point, and limit our jurisdiction to 3 things. What the division now has jurisdiction to investigate, it's anything to do with the election procedure. Anything, whether the notices, the actual meeting, the ballots, anything related to the election, that's one of the things we have jurisdiction to investigate. The other thing we have jurisdiction to investigate is anything related to financials, whether it's your budget, your annual budget, whether it's your financial statement, whether it's your, as I said before, your special assessments done improperly, your accounting records, misuse of funds, any situation that has to do with financials, we have jurisdiction over the whole thing. And the last thing we have jurisdiction, and it's actually our #1 complaint that we get normally in our office, it's record access. It's when a unit owner asks to review the records of the association and the association doesn't provide them. And that, believe it or not, is like our main complaint that people constantly, because once the association doesn't give the records to the unit owners that they want to review, right away, red flag goes up. What are they hiding? What's wrong? So that's one of the major complaints that we have. And we will help try to get you those records. We can, start off with just trying to get you that appointment to come in and look at the records. We can actually mediate in cases that, there's a difficult situation between you and your association. We can actually mediate, have an investigator sit there and make sure that you get the records. If your association is really difficult, we can subpoena the records. So there's a lot that we can do to help you get what you want, so you guys can see what it is that, you want to see. We're also going to educate you as how to properly do it, how to correctly ask for it, and to ask for what you really need. Don't ask, because a lot of people do the same thing. I want to see all records of the association. It's a 1,300 unit building, and I want to see it for the last 7 years. Well, they're going to bring you in a room this big with 100 boxes to 200 boxes and say, well, here you are. Go get them. So it's good that the unit owner knows what it is exactly that they're looking for. If they want to see bank statements, fine. If they want to see any kind of situation, kind of narrow it to what you really want to see. So that's our third thing that we have jurisdiction to investigate. And again, we do a lot of those. So we're really, versed on trying to get you what you want. Okay? So those are the only 3 things. Everything else in the book, unfortunately, we have no jurisdiction. So it's going to have to be a civil matter or a court if you need to, to enforce something in that thing. Sometimes I refer back to the attorney. If it's something that I really can help you with, I say, well, contact your attorney or contact the association attorney, and then we'll go from there. So having said that, let's just start with the unit owner's right and responsibilities, okay? The state of Florida provides a number of rights for condominium owners through Chapter 718. Florida statutes, also known as the Condominium Act, and the corresponding administrative rules 61B through 61B24 of the Florida Administrative Code, and that's the yellow book that you have in your hands. Along with these rights come various responsibilities that correspond to the type of community living. This presentation summarizes the rights and responsibilities of unit owners under the Condominium Act. You should refer to the statutory section or rules for the exact language of each cited violation. As you see as I go through, there'll be the cited Florida statutes on there. But again, you can look in through as we go, not as we go along, but later on you have a reference to that. Based on the fact that you do have the presentation and it has the same information on there. You may also get copies of that. I can give you copies if anyone, oh, by the way, my car is in the back as well. If anybody needs to take my car, by all means, it's sitting in the back. I can provide you books if you need books for your association or for your board. I can also do that. That's not a problem. You can go on our website and order it as well, but if you want, I can go ahead and send them to you. Rights of unit owners in reference to meeting and notices. Notices of board and committee meeting must be posted conspicuously on the association property at least 48 hours before the meeting, except in the case of valid emergencies. And as I was saying before, that's on section 718.112.2C. So you can make reference to that in the book to get you a little bit more of detail. Attend board and committee meetings, except meetings to discuss personnel matters or meeting between the board or a committee and the association's attorney with respect to proposed or pending litigations when the meeting is held for the purpose of seeking or rendering legal advice. Receive notice of meeting at which the board shall consider a special assessment or changes to rules concerning unit use. Notice must be mailed, electronically transmitted, or personally delivered and posted on the condominium property at least 14 continuous days in advance. Receive written notification of any special assessment which states the specific purpose or purposes of the special assessment. Receive notice of the annual meeting along with an agenda by mail, electronic transmission, or personal delivery, and by posting in the condominium property at least 14 continuous days in advance. Receive at least 14-day advance notice of a budget meeting along with a copy of the proposed budget. So when you get that annual budget meeting notice, that proposed budget must be included with that notice. That's very important. By mail, electronic transmission, or personal delivery. Receive notice of any legal action by which the association may be exposed to liability in excess of insurance coverage so that unit owners may intervene and defend on their own behalf. Speak at board, committee, or annual meetings subject to reasonable restrictions. The restrictions are basically, you need to talk about what's on the agenda. Not bring up, if the agenda is the annual meeting, the board doesn't really have to be there to, if you want to talk about the painting, if you want to talk about the roof, that's not something that's in the agenda. So basically what the rules are, try to stick to what's on the agenda. If a unit owner wants to talk about something and it's not on an agenda, or not, let's say for the next month, if you get 20% of signatures from unit owners, you can present that to the board, and the board in their next meeting or within 60 days can actually put that item that you want to talk about in the agenda. So if there's no meeting coming up, they have to have a special meeting within 60 days and put that item in the agenda, so then the unit owners can discuss what goes on, okay? But the restrictions are normally 3 to 5 minutes. Talk about any item on the agenda. If it's the budget, obviously you're going to talk about the budget, what's in the line items, what you don't understand. So it's limited to that. I know a lot of associations also, at the end of their meeting, open the floor up to any questions, and that's okay. But the requirements are literally talk about the items on the agenda, okay? Record board, committee, or unit owners meetings subject to reasonable restrictions. That's when somebody wants to videotape or somebody wants to FaceTime and do a video. That's what they're talking about. And the restrictions are, bright lights, don't get in front of the people, try to get on one side. So not to disrupt what's going on in the meeting. Receive notice of a personal levy or a fine or suspension of use rights for a document violation at least 14 days prior to the meeting. with an opportunity of a hearing before a committee of unit owners before the board can impose the fine or the suspension. So basically, if the board is going to impose a fine, they have to send out a notice 14 days prior. They have to give the unit owner the right to go in front of a committee hearing. And basically, the hearing is other volunteer unit owners that are not related to board members at all. So it's just like a impartial committee. And you're going to go in front of them, and that committee is the one that actually decides whether that fine is imposed or not. If the committee doesn't feel that that was a fair fine and says, no, we're not going to impose it, the association cannot impose it. So that's how all of that process needs to be done. Elections. Receive the first notice of an election not less than 60 days prior to the election, either by mail or personal delivery. Submit his or her name in writing as a candidate for election to the board not less than 40 days prior to the election. And what I just like to say in here quickly is don't wait to the last day. A lot of people do that. They wait to the very last day to turn in that intent to run, and things can happen. The office may be closed for an emergency. The management company may not be available, and your intent to run is not going to get in. Because even if it falls on a Sunday, that's the last day. It doesn't carry over to Monday. That's the last day. So normally on that first notice of election, usually the associations will give you the day that that intent to run is due. But again, don't wait. Just go ahead and send it in as quickly as you possibly can. Submit candidate information sheet not less than 35 days prior to the election. That's basically a resume of why you want to be on the board, what are your education, why do you think you feel that, this is, you have a background that can be helpful and the board. That's what the information sheet is. That's not a requirement, but if you are, you got 35 days before the election to turn that in. And that has to go out with the second notice of election, along with the ballots and the envelopes, that information that you provide to the board. Receive a second notice of the election, a ballot or inner envelope and outer envelope, and copies of any timely submitted candidate information sheets not less than 14 days prior to the election, no more than 34. And the reason for the 34 is, as I said before, the candidate information sheet is due on the 35. So actually, literally, the next day, the association can send out that second notice of election. So it's no more than 34, no more than 14 days. So there's a window, especially if you have a lot of people that don't live here year-round, that you may have to mail it to Canada, you may have to mail it out of the country. That gives them a little time to get that and get it back, with their ballots and information sheet if they want. Vote for the board by written secret ballot or voting machine if there are no more candidates than vacancy. What that means is that if your board consists of 5 and only 5 people put in their intent to run, no election is required. Those 5 people will automatically come on the board. The only time you have a board is when you have more candidates than positions available on the board. That's when you actually have to have an election. Your annual meeting has to occur no matter what, but on the second notice, if you're not having an election, you can just go ahead and put on there, we didn't receive enough candidates, therefore the remaining board continues on, or here's your new board of directors, okay? So only when it goes over that you're really required to do so. Vote for the board by limited or general proxy if different election procedures are approved by a majority of the total voting interest and are provided for in the association bylaws. Limited proxies and general proxies may be used to establish a quorum. Limited proxies shall be used for votes taken to waive or reduce reserves in accordance with subparagraph F2, for votes taken to waive the financial reporting requirement, or for votes taken to amend the declaration pursuant to 718.110, for votes taken to amend the articles of incorporation or bylaws pursuant to this section, and for any other matter for which this chapter requires a vote of the unit owners. Proxies are not used for elections. Proxies are only used for a quorum to meet either in person or if you wanted somebody to bring in your proxy for a vote. But for elections, proxies are not used. So that's another interesting thing. And what happens a lot in this situation is because you're having the annual meeting and there might be a vote of something that they need the unit owners vote at that point, a lot of associations will, in the second mailing, send in the proxy. And a lot of people call in and said, oh, my association sent in a proxy for the election. And I'm like, no, that's a proxy for a vote that is going to be required that you guys vote either in person or by proxy. But that has nothing to do with the election procedure, okay? Vote at a meeting or by written agreement with the majority of all unit owners to recall any board members. Association funds receive annual financial reports as follows. If the association consists of 50 units or fewer, or has revenues of less than $150,000, then within 21 days after the final financial report is completed by the association or received from the third party, but not later than 120 days after the end of the fiscal year, or other date as provided in the bylaws, the association shall mail to each unit owner at the address last furnished to the association by the unit owner, or hand delivered to each unit owner a copy of the financial report, or a notice that a copy of the financial report will be mailed or hand delivered to the unit owners without charge. So your financial statement has to be done within 90 days of the end of your fiscal year. A lot of associations are January 1st to December 31st. So 90 days after that, which is February, March 30th, the financial statement has to be prepared. The association has to 120 days to mail you that, either that financial statement or a notice stating, if the financial statement is too big, if your association is real big, you're going to do an audited financial statement, which could be a lot of pages. The association, in lieu of sending that out, can just send out a notice and say, it's available, whoever wants it, please ask for it, and that's at no charge. They have to mail it out to the unit owner. Or the unit owner can go and pick it up as well, either way to do it. The same consists with associations of 50 or more units and over $150,000 of revenue. So there's three different types of financial statements. There's one and two different types. One is a cash review and expense, or cash receipts and expenses, and then your financial statement, which is either a compile, a review, or an audited financial statement, depending on the amount of money that your association has in total revenue. So that's how you get your financial statement. But this is mandated in statute, and it's time restricted. The budget is not. The budget can be at any point in time in that year, and it doesn't have to be a year from the last time. So it could be, let's say 2013 budget could have been done in January, and the budget this year may not have been done yet. That's not a violation. It just says that it has to be done within that year. The financial statement, however, does have time restrictions. So no later than 120 days, you must have that financial statement or that notice on hand. Okay? If a board adopts in any fiscal year an annual budget which requires assessment against unit owners which exceed 115% of assessment for the preceding fiscal year, the board shall conduct a special meeting of the unit owners to consider a substitute budget if the board receives, within 21 days after the adoption of the annual budget, a written request for a special meeting from at least 10% of all voting interests. The special meeting shall be conducted within 60 days after adoption of the annual budget. So if you're not happy with the annual budget and you have a choice you can do. If you get 10% of unit owners and present that you want to do an alternate budget, the board has to provide that. Either the unit owners can actually do it, and that really has never happened that I've known of, but the board can actually go back and review that budget and see if there's something that they can do to make it better, and then present that budget, and then it has to be voted on. But it's also voted by the majority of the board members. If the vote is not received, then the actual budget that was adopted, that's what goes on for that particular year. Also, pay assessments on a quarterly or more frequent basis. These are all unit owners' rights. Generally, exclusive ownership and possession of the condominium unit, membership in the association, and full voting rights as provided in the Declaration of Condominiums, unless your rights have been suspended for non-payment of any association funds. Then the board can actually suspend your voting rights. Use the common elements in association property without paying a use fee unless the declaration or condominium so provides, or the unit owners by a majority vote of the association approve of such a fee unless the charge is related to expense incurred by an owner having exclusive use of the common elements or association property. Use of the association's common element, common areas, and recreational facilities together with their invitees' guests in accordance with the condominium documents and properly adopted rules and regulations of the association. The association can also suspend use rights for unit owners or for your guests or your tenants that violate the rules or any part of the bylaws of the declaration. The association can actually suspend the use rights of that unit owner or that attendee or that tenant. The association can actually suspend also the use rights for failure to you to provide, to pay your maintenance on regularly. They can also do that as well. Inspect the association official records subject to the reasonable rules adopted by the association. Some associations have rules depending on, in some cases, you have chronic unit owners that constantly are asking for records. They just go into the office and say, I want to see this, I want to see this, I want to see this. I know you know who I'm talking about. So, I know exactly. Yeah, I saw your head bobbing. So, there's a lot of unit owners that actually do that. There's a procedure to do that. You need to ask for them correctly. You need to make sure that it's sent handwritten. Email, it's not acceptable. The statute hasn't been updated to emails yet, so it basically has to be handwritten, either given it to the property manager or given to any of the board of directors, the association, and it's to review records. And that's also a misconception that happens all the time. Unit owners say, well, I want copies. Just mail me the copies. I'll send you a check. It doesn't work that way. You have to review the records. What the association responsibility is to open up those records for you to look at them. If you want to make copies, then you ask the association to do so at that time. But their responsibility is only to provide those records for you to review. And within 5 business days of the date of that receipt. I suggest always send a certified mail or hand deliver it. If you hand deliver it, take 2 copies and have whoever you handed it to put the date and their signature on both copies. That way they have consistency of that. Okay? Yes, ma'am. Is there anybody else you can give it to? The manager has a responsibility to take it. Okay. You can, that would be something that you can, if you can get them to, if they didn't provide. Right. That's what I was going to say. Certified mail. Well, the good thing with certified mail is once you get the green card, that's your receipt. Now they have it, and now it's the and this is another thing too. It's the responsibility of the unit owner to make the contact. Because a lot of times we get the call, well, I sent it in 30 days ago and I haven't heard from the board. And our first thing is, have you contact the board? Have you say, you got my request, when can I see those records? Oh no, I'm just waiting for them to give me a call. No, it doesn't work that way. Again, the unit owner has to make the attempt to, once he got that green card back, you make the call. Okay, you got my request, when can I see those records? And if you throw in within 5 business days, they know you know the law. So it'll make it a little easier because they realize that, okay, they know what they're talking about.
I'm sorry. If somebody requested a bidding process for something that over the last couple of years on projects, we would not have to, as a board, we would not actually have to give them precisely what they wanted. We just say it's in a box, hand them a box, and they'd have to review it.
It depends on what they ask for. If they ask for only a certain thing, it's probably more beneficial to you to give them what they want than just put them in a room with 4 or 5 boxes and say, well, it's there. It's going to take 3 to 4 hours. So if you provide if they're consistent enough in what they want, if they want to see the bids that were for that project, you know exactly what they're looking for. It's a lot easier for you just have those bids ready and say, here it is. Now, if they're in a box and you really don't want to, that's okay as well. You can say, well, it's in this box, and they look for
Or we could charge them for to looking up the different.
No charge. Unit owners don't get charged for record access. The only charge they get is if they actually want copies that the association is going to make. That's the only time that the unit owners get a charge. There is no charge. A lot of property managers charge for their services because it's their time. So they can charge, but they charge the association, not the unit owner. The unit owner doesn't get charged to review the records at all, ever. Whether it's at the attorney, if you keep your records at the attorney, whether it's at the property management company, if that's where you keep them, or whether it's in the condominium. Now, there's what it says here, also reasonable rules. It's up to the board to provide those records within the convenience of the board. It's now, it doesn't become the unit owner's convenient. So if the board, let's say your documents are in your association and all your board members work, for you know, everybody works, and you say, well, I can provide those records Wednesday from 6 to 9. That's fine. The unit owner has to accommodate himself to that. Or the versa of that is, your records are at a management company, and the management said, well, we only do record access on Wednesday and Thursdays from 10 to 2. The unit owner may work, well, he's going to have to make accommodations to be there from 10 to 2, because that's what your convenience to do. So it's, you know, it's a work in progress, but your documents, the easier you provide documents to unit owners, the less they ask for. And that's always been a thing. We have a lot of associations now that have websites. And in their websites, they put everything. They put bids, they put, you know, budgets, they put all of that. And that is so much easier because the unit owner can go in with a, you know, with a passcode that they get and see whatever they want. So it's more transparency, it's better. The less you're going to have people asking for records. And like I said, the moment you deny the record, the red flag goes up and people are like, okay, why are they hiding? Why don't they want me to see that? And that's always the same issue. So the more transparent you are, the better it is. But the unit owners, and actually I'm going to go into it in a minute before I get into that. The association must make its records available to unit owners within 5 working days, as I say. The right to inspect the records include the rights to make or obtain copies, the reasonable expense, if any, of the unit owner, if he asks the association or the management company to make the copies. But the new law, and that's what C is, it just came into effect this year, the right to inspect the records include the right to use a portable device, such as a smartphone, tablet, portable scanner, or other technology capable of scanning or taking photograph, to make an electronic copy of the official record in lieu of the association providing a copy of such record. The association may not charge his or her authorized representative for the use of a portable device. So they can come in with an iPad, they can come in with a phone, take pictures, whichever way they want. And don't charge him for electricity. I know association wanted to do that because the guy brought in his own, you know, copier, and they were like, well, he's using our electricity. And no, it doesn't work that way. So basically, but there is no charge to the unit owner unless he requests copies. And copies, the statute also says reasonable amount. It doesn't say a figure. So reasonable amount could be anywhere from 25 cents a copy to $1 a copy. And the reason why $1 a copy is because the association may not have a copier in their office and may have to take it to Kinko, or they may have to take it to a printing company, and that's their charge. So you can charge what they're charging you for the copies, but you can't charge over, you know. I had a property manager that when the unit owner filed a complaint, I called her and I said, well, the unit owner says that you're charging her $40 an hour for record keeping. I said, what's record keeping? She said, well, that's for the guy that's going to sit there while she reviews the record. We got to pay him, you know, his salary, and that he's the record keeper. I said, no, that doesn't work that way. You want to charge that to the association because it's in your contract to do so, that's fine. But you can't charge the unit owner for that. She said, well, that's our fee. I said, then deal with the association on your fee, but don't charge the unit owner. So unit owners that's something that they get for free, okay? Receive a stamped written response to an inquiry submitted by a board by certified mail. That's when an association writes the unit owner writes the association. A written inquiry, it's like a questions. It's a series of questions that you want to ask your association. You know, what's going on with the painting, or what happened with this money, or what transpires with this. What the statute says, the association has to reply back to you within 30 days. If they send it to the attorney to get an opinion, or for the attorney to reply, it's within 60 days of that receipt of that written inquiry. And if they send it to the division for a legal opinion, or for the division to answer the unit owner, then it's 10 days after we supply you the reply. Okay? That's what the written inquiry is. But, and I say this to all the unit owners as well, that's not a demand letter. That's not a record access request. It's a written inquiry. It's questions that you have for the association to reply. That's what a written inquiry is. And a lot of people put them together, which is wrong, or a lot of people just make demands. Well, they didn't answer my letter, and when we look at the letter, it's all demands. Why, you know, the association is doing this, the association is in violation. That's not a written inquiry. So that's the difference between those things. Email, it's not. Like I said, the statute hasn't come up to the 21st century yet all the way. It's done some good stuff, but still there's the only, and if you see it where it says electronically transmitted, that's transmitted to unit owners that have consented to receive notices by email. So they have to consent. Let's say, again, they don't live here half of the year. They live in Canada. They give you the email address and consent and say, this is for the purpose of only receiving any notices. You can send it to me via email. That's where the electronic part goes.
Has fax reached the 20th century?
Fax, yeah, you can fax stuff, and basically your receipt, it's your thing, but it's written. You know, you wrote it and then you faxed it. In one of my presentations, I have telegraph. I have to take that off, but the statute still says telegraph on there. So, you know, it's come a long way. Apply to the circuit court of the county in which the condominium is located for a receiver if the association fails to fill vacancy on the board sufficient to constitute a quorum. This really doesn't happen often, but it's a tool that you can apply to, because a lot of building, especially where there's a lot of elderlies, nobody wants to run for the board. Everybody don't want the hassle, the headache, you know, the extra work, and you end up not having a lot of people on the board, or maybe just one person. Well, in lieu of that, the association can actually request a receiver, which is appointed by the court, to come in and run the association. That's very costly, because normally that's an attorney, and an attorney is going to charge his dual fees to run that association for the time and the period that, you know, they're required to do so. So that could be very costly to the unit owners if they don't really want a board. And that's something, like I said, you can use it as almost like a, you know, I don't want to say a threat, but kind of like a tool that if we don't get people to get on the board, this is the other avenue, and it's going to cost you thousands of dollars for that, okay? Participate in the voluntary mediation or mandatory non-binding arbitration process to resolve certain disputes. Vote to cancel any grant or reservation made by a declaration, lease, or other document, and any other contract made by an association prior to turnover of control to the unit owners other than the developer. Bring action for damages of injunctive relief on both against the association, another unit owner, a tenant, or invitee on our director who willfully and knowingly fails to comply with Chapter 718, the applicable administrative rules of the condominium documents. Unit owners have the responsibility, and this is now changing what the unit owners are responsible to do. Pay their share of the common expenses as defined in the statute and the condominium documents. Use the common elements in a manner that will not hinder or infringe on the rights of the other owners. Provide the association access to the unit during reasonable hours for the following: to maintain, repair, or replace any common element, to prevent damage to the common elements or other units, or to maintain the unit as required by the declaration of condominium. One of the laws that changed, I want to say last year, and now this year has changed with the co-ops, it's that it gives the right to the board to come into an abandoned unit, repair it, fix it, and do whatever it's necessary to make sure that nothing is gonna hinder, or that unit is not affecting all the other units. So the unit owner has a right, the board has a right to come in. There's a little bit of a procedure, it's actually on 718, where it talks about I think you have to send a notice 2 days to either the owner or the tenant that was there before. If the unit has been vacated or empty for 2 months, all you have to do is send that 2-day notice to the last address you have, and then you can come in and do any repairs and charge the unit for it. A lot of people, as you well know, a couple of years ago, things are getting better now. They just walked away. They just left the unit. Didn't turn on their lights, their electricity. We got mold in Florida. A lot of things could happen. Now the association can actually go in, repair it, and actually even rent it if they need to try to get some money from that, okay? Use the common elements in a manner that will not hinder or infringe on the rights of the other unit owners. Provide the association access to the unit, we talked about that one already, to prevent damage to the common elements and to maintain the unit as required by the declaration. Not make any alterations to the units that would adversely affect the safety or soundness of the common elements or any portion of the association or condominium property that association maintains. Comply with the provision of Chapter 718, the applicable administrative rules, the declaration of condominium, the articles of incorporation, the bylaws, and the rules in association. There's a lot, but that's basically what governs your condominium, and that's basically what you're responsible for. And I get this all the time as well. People buy, and then all of a sudden a special assessment comes through, and they're like, well, if I would have known this, I wouldn't have bought into it. I said, well, did you read your documents? Oh, no, I didn't read that. That's a lot of paperwork, and it's just, okay, well, that's what it states, how a condominium is to run and what the association has the power to do. And that's very important for people to read that. And that's what guides you. That's what guides that condominium. And that's what tells you what your rights and not, or the rights of the board are. So they're very important documents to actually look over and read. Attend and participate in unit owners meetings, attend board and committee meetings, vote on issues presented for a unit owners vote and election, cooperate with unit owners in day-to-day community life, bring any concerns or problems to the board of directors' attention, serve on the board of directors as needed, and be familiar with the provisions of the condominium documents. And I say this all the time, a lot of people, when you live in a condominium, you're in a community. Everybody is involved. Everybody is responsible. We've had issues, especially when the hurricane hit, where there was 2 or 3 buildings. One building got destroyed and the other 2 didn't, and they were upset because, well, why do we have to pay for the third one? You're in a community. So everybody pays for the share equally as well for any special assessments or anything that needs to be done. And that's what people have to understand when you live. Yes, your unit is your domain, but you're part of a bigger picture that actually everybody has to be responsible for, okay? And that's it. That's short. Well, we're still in time. Any question? Go ahead.
What could we do if we have a manager that's not capable to be able to handle the safety of our building? In other words, under various times, we've been under very unsafe conditions that we've been living in. And I don't know what I have proof to show how unsafe our building was, but what could we do if the manager is there and we have no way to, what power could we have to show the danger of the situation where he makes the decisions with the contractor?
Okay. The manager is hired by the board of directors. That's a business decision of the board of directors. The managers are governed by our sister division, which is the Division of Regulations. They're the ones that control, because managers have a license, and they have to protect that license, okay? Our board members are volunteers, so there's no license, no requirements, except that you take the course and within 90 days and so on and so forth. But the managers do have a responsibility because they have a license to protect. But they're hired by the association to help them run the association. If a manager is not doing the correct thing, our sister division will open a complaint against them. And investigate them, just the same way that we do when we investigate an association. And then it depends on that finding whether they cite them a violation or not. Again, in this situation where the manager may be doing things on his own, but technically it's the board that hires them. And one of the things that I say to people all the time is, your manager doesn't, the board runs the manager doesn't run the board. So that's the reason for the manager is to help, is to assist, because he knows the law. He knows what needs to be done and how it needs to be done. That's why you hire a property manager. If he's not fulfilling his duties, then it's the board decision to say, well, talk to an attorney and have him review that contract and for ways to cancel that contract. But again, if it's something that he's doing really illegally, then you can contact the Division of Regulations and they will.
Where are they located?
They're all over also. Take my card and and call me or email me and I'll send you that information.
All right, could I also ask the same question in reference to the board? If they're not capable of properly running a board, for example, to my knowledge, you need a president, a vice president, a secretary, and a treasurer as the four components of type.
Minimum. Normally it's either 3 or 5,
Okay,
depending on what your documents state.
At the particular time now, if we don't have a vice president, is the board officially operating correctly?
Yes.
They can
Yes.
without the
Yes.
fact that there's no vice president?
Yes. As long as your board, how many
Well,
board
there's
members?
9 members on the board.
Okay.
But the idea is, according to what the management's contract is, he has permission to contact the vice president if the president is not there.
Mm-hmm.
Considering that there may be decisions to be done and the president is not there and we have no vice president, where does the manager go?
Well, the manager can go to the treasurer, the manager can go to another board member. Those are titles for officers, but everybody is a board member. All 9 members are board members and they're responsible for the operation of the condominium. If you have, let's say for instance, your president, your vice president, and your treasurer leave the country for 6 months out of the year, and the only residents or live-in are your, secretary and your directors at large. They can make certain decisions that are important. They can also have meetings and bring them in. And that's another thing that I'll mention now so I won't forget and I'll come back to you. Actually now, one of the new laws that also changed this year was that board members can actually be at a meeting via your tablet or your phone, via Skype, via FaceTime, or anything like that, and it counts as a vote. So if you have a tablet and that person's face is on there, and he can hear and he can speak, that's a vote. It counts as a vote. So technically, one lady asked me, she said, well, I'm the only one, throughout the whole summer here. Can I then have 4 iPads and that's a meeting? I said, absolutely. As long as they can hear and they can vote, then you're fine. But the board has a fiduciary duty to the unit owners as well as to the association.
Well, if the board doesn't show appropriate manners to protect the unit owners as far as safety, and I have an article here, it was fortunately written in New York, where a fella died because of the fact that the railings and balconies weren't safe. And I could prove we had the same situation in our condominium, and basically nothing was done for a long period.
It's your condominium. How old, let me start with that. How old is your condominium?
Condominium is over 40 years.
Did they do the 40-year recertification?
Well, what they're doing now is, unfortunately, the board doesn't seem to know how to make the proper decisions. This happened about 2-3 years ago when the board decided to patch up the balconies on our condominium. So they invested about $200,000 just to patch it up, where nothing was accomplished. And if they would have did the proper thing and started with the 40-year inspection, we could have completed at least a minimum of two units completely done. But they just mismanaged the whole building.
Okay, there's 2 things you can do. Either when the elections come, have people campaign, have people put in their intent to run, have people get on the board. That's one thing. Depending on where your election is, how close it is to what we're talking about right now. The other thing the unit owners have a right to do is do a recall. And a recall is a process, it's a little bit more intensified. You need recall forms, you need signatures from unit owners. Normally it's 51%, in some condominiums maybe up to 75 that you need to present to the board. There's a whole process of a recall process. That's the whole recall pamphlet and booklet that we have, it's on our website. And you can download it or print it, and it'll tell you step by step how to do a recall, okay? And basically you can recall 1 or all 9 if you want to, as long as you have 9 people to replace them, okay? That's the only 2 things you can actually do in the interim of one thing. Now, if your elections are close by, then the recall is not going to work for you, because you can't do a recall 60 days before an election or 60 days after an election. So your only other option is get some people on the board that care. Get some people, and I know you're going to tell me that's actually the same thing I said before. Not a lot of people want to get on the board. People don't want the headache. People don't, and that's the problem that happens where boards go on year after year. It's like I get people to tell me, my president's been there for 15 years, and he's 84 years old. Does anybody run for the board? No, nobody runs for the board. Well, he stays on until he, hopefully, or unfortunately, he dies. You know, that's a problem. But it's you getting all the unit owners that are unhappy as you are, or, you know, they see the liability that may happen. It's say, listen, we need to get new people in there that would assess everything accordingly and do the right thing.
Well, unfortunately, we need a manager who is capable to give the board a decision.
That I'll give you.
We don't have that now, and that's what I'm trying to find out.
Okay, well, I'll give you the information, and then you can do that, okay? But that, again, it's a board decision to do that. I think this lady, I don't know if somebody else had one in the back.
Thank you. In your presentation, you had a bullet point that said something to the effect of common areas that should not infringe on the rights of other owners under a responsibility of owners page.
Right.
I think what is a gray area I'd like to get your opinion on, and it has to do with balconies. My next door neighbor is an incessant smoker. She doesn't smoke inside her house. Her balcony ends literally 3 to 4 feet from my bedroom window. So there are many times I left my window open during cool days, and the entire house, especially the bedroom and the closets and the drapes, stink. So essentially, I cannot open my windows at all in the house, in most of the house, ever. I know that balconies are considered limited common.
It's only used for that particular unit.
Right. So the limited common just seems to be a fancy name for its exclusive use of, and
Yeah,
there's
and
nothing,
that's what it is.
and
No,
there's nothing
it's
I can
exactly
do
what it
about
is.
that, right?
Right.
Okay.
Absolutely nothing, unfortunately, you can do, because that's her space, basically. But a limited common element, it's only used, it's a space, whether it's a lanai, or whether it's a balcony, or whether it's a screen porch, that it's only for the use of that particular unit.
Does noise constitute go under that same category as well? Partying out there late at night and everything else?
Yeah,
Okay.
it's called security, you know, the
Right.
police, I mean, but unfortunately with the smoking,
Okay.
right. I mean, after 10 o'clock, you can't have loud noises, but what happens in condominiums a lot is associations or unit owners put tile floors and they don't, you know, soundproof them enough. And people complain all the time. I can hear everything that goes up there. I can hear when somebody's walking. I can hear the dog, you know, little feet. That's something that's internal. You know, that's not something that the division or anybody has. Because like I said, once you're in your unit, that's your unit. Now, you're not supposed to disrupt, you know, everybody around. But smoking, it's not something that, you know, you can limit her to do something in her unit. So.
Given the example you used before about someone purchasing a unit and then a special assessment being passed and the owner saying, well, I didn't know about it, some of that I understand has to be covered in the question and answer form that the association has to give to any prospective unit owner. But it's a twofold question, really. Mm-hmm. What if the board has considered and distributed information of potential upcoming assessments? Do those have to then be listed because the board is considering it? And what happens if the board does not list it on the question and answer form?
The question and answer form, it doesn't really, there's no specific, oh, hold on. There's no specific detail as to what needs to be on that question and answer sheet, okay? Now, what a unit owner or a potential unit owner is responsible for, and sometimes even the realtor will do this, is ask for your financials. Ask to see how many your reserves, what you have on reserve, what money you have on your financials, how is your, what was your financial statement like, what was your budget like, do you have any kind of money? Because this is going to tell you whether a special assessment is going to happen or it's not going to happen. And that's something that the unit owner or a potential unit owner is right to do. Now, if a proposed or pending special assessment, it's not said or it's not approved by the board yet. They're considering it, like you said. So the interesting part of that is if a person is in the process of buying, even though the board said they might pass that special assessment, they're still not responsible. Because if the new owner comes in, then he will be responsible. Now, if the special assessment is passed and that person is in the process of selling, he's responsible for that special assessment or negotiating with the new owner, well, you pay half, I'll pay half, kind of deal. But it's basically how it falls into what they're going to pass. But the board, and that's something that I tell people all the time, a lot of unit owners waive the reserves. I think that's just a really wrong thing for people to do because now you have no money. And the board can pass a special assessment as many times as they want in a year. There are no restrictions as to when the special assessment can be passed. There are no restriction on the amount of money that can be passed. There are no restriction on the amount that they require you to pay. They could do it on over a period of 12 months, 6 months. Some associations, because it's an emergency, let's say there's a big leak in one of the buildings, may pass a special assessment and say you have to pay it within 30 days. Mm-hmm. That's why reserves are so important, because that's money that hopefully you have put away, so the unit owners are not offset that much. But it's up to the board when they do it. But potential, they're talking about it, that's not an adopted or approved special assessment. Okay? Thank you. Wait, hold on, there's the other unit.
Can you tell me, in a condominium where there are small children and infants, are there any limits as to the swimming pool, as to what age a child can go into the pool?
Those are rules and regulations that the board has to make. That's not something in the statute anywhere where it says, under 2 years old they can, no. It's something that as a rule, because it's not in your documents, as a rule, the board may say, well, no children unattended under 10 or, depends.
But I'm talking about in diapers or must they?
Yeah, but there's no language in that whatsoever.
And you might have it in your bylaws or your.
And your right.
It doesn't mean anything because you go through the HUD, or you go and basically what could happen is that you'll end up getting sued because. You say a baby, a child, but how about an adult that might need a diaper? The same thing. So you're being, you're being prejudiced against a child.
You're
so you can't do anything.
Yeah, you're absolutely right about that. The lady over there. Oh, okay, yeah, that's right.
Hi.
Hi.
I have a few questions.
Okay.
Number one, I'm a realtor, so kind of one of the things just recently I was taking my renewing my license, and it came up to me because a lot of condominiums pass new rules, like for example, rental restrictions. Some owners bought a unit, and then a year or two later, they pass a rule, no more rentals or certain things. It was my understanding that it says there that the people who own the units prior to that law are still allowed to rent their units. Is that correct?
That's something internal. That's not something that, again, the statute has any jurisdiction over.
No.
They may be grandfather in. It's
Right.
what they call, if you're in the unit and you've been in the unit for a while and you've been renting your units, you may be grandfather in. A lot of associations, what's happening is, and again, with the market the way it was 4 or 5 years ago, a lot of people were just buying and renting. What happens is your association becomes 25, 30, 40% rental in your community. Well, there's a couple things that could happen there. Number one, to get a loan, it's almost impossible because that's what the banks are looking for. And second of all, your insurance may realize that you have over 30% of renters and may actually change your policy from residential to a commercial, and it's going to cost you double. So those are the things that, you know, a lot of associations, and that's an internal rule that can be on your, also on your, as you said before, in your documents, that say only 20% can be rented, only 10% can be rented. But those are rules that can be changed at any point in time, and that's not something that the division has any jurisdiction over.
Okay, now, another question I have also with rentals, since we're like such a beautiful city and community, a lot of people are turning the units that you cannot ever rent, or you can rent once a year or twice a year, into like short-term seasonal rentals, mostly in some of the buildings into hotels. You have people moving in and out every week or every 2 weeks, and on all the top of that, they're not even collecting the hotel tax. So I want to find out, first of all, does the building, there's certain buildings that allow, I think it's one building in our city that allows rentals 12 times a year. So I was understanding if the lease is less than 6 months old, 6 months, you have to collect sales tax. Who enforces that? And is the building supposed to be part of that, or the city? Because if that's the case, and the city and the state are owed a lot of money for those short-term rentals, and how is it going to be enforced? Because I'm getting a lot of complaints about those short rentals. They're turning condos into hotels.
Again, that's a document enforcement, and it should be on your documents. If it's not on your documents, I would say the city what do you think? The city would be something that they look into, because like you said, if they're turning it into a hotel, I mean, condominiums are residentials, you know, and you got condo hotels, but their documents are specific to that. I think if you're changing your documents, I mean, it has to be a document enforcement or a document change.
Right, but they're not changing their documents, but I know that they just allowing that to happen.
So I would say the city.
So the city would have.
The city may be able to do something in reference to that.
I wasn't sure, but let me ask you a question. The other thing is, I'm always get into that. There's certain, like I thought the condominiums have to, like, responsible to look only to the state. So if anybody wants to file a complaint against their building, they have to go to the state, not the city.
They come through our division.
Through your division.
Right, within the jurisdictional that we have. That's not a jurisdictional that we have in reference to renters or in reference to how the association rents. The association basically says very limited to when it comes to rental, that if the board is the one renting the units, then those are records that unit owners can save, pretty much. And if the unit owner is the one renting the unit, then they go through the process of, you know, an application and so on and so forth. That's the only thing the statute says.
What about the city involvement? How? Oh.
He's gonna. Okay.
The city, is the city like actually is the city allowed to be involved in enforcing certain rules and regulations in the building?
If there's zoning and coding, yeah, absolutely. Absolutely. And that may be, go ahead.
And actually, to the gentleman's point,
Just one more question.
you had mentioned an issue about your building.
Yeah,
sorry. My name's Fernando. I'm Chatsky. I'm the deputy city attorney. You had mentioned an issue about your building. You were alleging life-safe, healthy health issues with the building, apparently with the balconies, and you were asking what could be done in that situation. Well, if it's a life, safety, health issue, you could contact the city's building department.
Exactly.
So that would be, you know, that's certainly one of the remedies that's available to you. I don't know if you've ever contacted the building department.
Right, and I think just to expand a little bit, I think the issue that what we're trying to say is if you feel like there's a violation of code, you're welcome to contact the city and we'll come out and investigate.
Absolutely.
We'll let you know if
Absolutely.
it falls under our purview or not, okay? Right.
And the reason what I was saying about the 40-year recertification is because all of that falls under that. When you do a 40-year recert, your balconies, your elevators, your walkways, your construction, everything is looked into, and it has to pass a city code. It's actually a city ordinance. It's not a division or a state thing. It's a city Uh,
Restoration, his balcony's being ripped down and they're just hanging there. Actually, you're correct. I overlook over your balconies in
Yeah.
months.
Well, we're going to let him speak to you about some of his issues
Okay.
one-on-one because
All right.
I want to make sure the group's questions
no
are
problem.
answered. Okay, ma'am?
No, the only thing I want to comment on is we had a horrible situation in Winston Towers 300 where it was a turnstile building all of a sudden. We didn't know who was there. Well, people were coming and going weekly,
right.
daily. I mean, it was totally out of control, and we were losing control of the building upkeep. And it really was, you have to work very, very hard. And we don't want to let people come into the building that had rules about renting, and then all of a sudden an influx of new people who changed the rules on themselves and broke the rules and practically destroyed the building. And so we are tightening every loophole because we don't want it to be a condominium hotel. So you have to understand. Well, we had a lot of trouble with realtors.
I would like to address, Mariana, something you brought up, Mariana, about the sales tax. I was under the impression it was, the onus was on the owner who was renting to fill out a tax authorization and submit it in their federal taxes that they took income on this property. And of course, it's the honor system, so nobody in their right mind would do it. They just don't do it.
It has nothing to do with the owner's personal income tax. It's completely different tax, and the money goes to, I believe, the state, the county, and the city would partially get, because I believe the city gets some of the hotel taxes. Yeah, but that's completely, yeah, that's between them. Right, but that's completely right. Right, but additionally, because if you properly do your lease, and if it's shorter than 6 months, you have to put there additional sales tax, or the sales tax is included in the lease, but people are avoiding it and turning, even 12 months buildings that you can rent 12 times a year, they rent weekly and daily. It's a disaster.
Okay, ma'am?
In our building, apartment 2206, every 6 months, that apartment has a new tenant. And
And
I
again,
agree
but that's
with what you
something-
said. I'm an owner, and I live in a condominium. I don't live in a hotel.
I know, I understand.
And it's very,
But that's, again, look at your documents, look what your documents say, and specify. Again, it may be that you can rent twice a year. That's every 6 months.
According to the rules and regulations of my building, an owner is not supposed to rent the apartment only 2 years after he buys the apartment.
Right. That's, again, an internal rule of yours. It's an internal rule that it was applied. And it might be a rule, and it might be an amendment that they made to the documents as well. So you got to look at it from the perspective. Okay. Interesting. I think this gentleman and this gentleman had questions.
Hi. Very quick question. Just wondering, I don't know if you have this information or not, but is there a statute that controls the number of residents per bedroom in a unit?
No, that's it's two, well, if it's a one bedroom, 2 persons. If it's a 2 bedroom, up to 4 people, is what technically, but that's not us. That's, housing, it's housing, HUD. That's the one that puts the rules, that's what you do.
Okay, but you would know what the statute is, though, because I've tried
No,
to find it.
that's
I can't.
housing. That has nothing to do with us either.
Yeah,
No,
okay.
that's housing. And I know that happens a lot where people, have 6, 7 people living in a 2-bedroom apartment. I guess HUD would be the one that you would need to contact in reference to that.
It also would be in your bylaws, it would be in your rules and regulations and
It might not be a rule, it might be actually in your bylaws or declaration.
definitely.
That's to the limit of what they can actually put. If it's silent, then pretty much you're open to anything, but I think HUD may be able to come in and because it's a safety issue to be, to actually So,
What happens if you have a very powerful manager and at the same time he's a board member? And he's basically controls the board and the building, and you feel that he's taking advantage of the situation where he could be taking kickbacks and different things. What do you do? When you have the board itself is basically manipulated, or he's controlled by this individual that actually, again, he's the property manager with a CAM license, and he's also a voting board member.
he's a unit owner, I'm assuming.
Correct.
Okay.
And
Okay.
he's,
As I said to this couple over here, you have options. It's not a conflict of interest as long as it's disclosed that he's also on the board as well as a manager. What can happen is if it goes up to a vote where it will benefit him as a manager, he should abstain from voting. That's the only requirement, basically. He should abstain from voting if it's something that's related to him. My suggestion is that's not a good fit because, like you said, him being on the board and also being on the property manager side can create some difficulty in what's going on. My suggestion is, again, one of the various things that I said before. Either recall that person. You can recall one person if you want. Either not vote him in on the next elections. Talk to people and say, if he wants to be a manager, let him be a manager. Let him not run for the board kind of deal. Or if the board, and it's going to be difficult because obviously he's saying he controls the board, if the board decides they can cancel that contract, but they have to also talk to an attorney, as I said all the time, make sure you read all the fine print in that contract to break that contract. But there's really not a conflict of interest. And when you're talking about kickbacks, that's criminal. That's not compliance, that's criminal. Very hard to prove, because a lot of those transactions, are cash. So, but let me explain something else. There are other forms of kickbacks, and I'll give you a perfect example. It's not money. The association decided to put this beautiful carpet in all the floors, and all of a sudden, the president has the same carpet. He didn't pay for it, but it's a kickback because it's services rendered. It's a gift. It's service rendered, and that's a kickback. So, and it happens all the time. Kitchens, painting, rugs. This thing is driving me crazy. Painting, rugs, tile floors. So there's different types of kickbacks, but the problem is it's very hard to prove because it's as guilty as the one that's doing it as the one that's receiving it. And it is criminal. You go to the police or you go to the state attorney's office and they will handle those things. But again, it's very hard to come through and prove that. My suggestion is, as I said, to do, campaign, talk to other unit owners, have meetings. Unit owners meetings are meetings of just unit owners. There's no decision made at that point. No board member has to be present. Unit owners can have meetings, 14-day notice, post it, send it out up to everybody, and let them know and discuss situations like that. If you want to get them off the board, campaign. But you have to have people that want to get on and get him off. If you don't have that type of people like that we're telling here, then they're going to continue on. And they're going to continue on, and they're going to continue on. So the unit owners have a responsibility to make sure that who they put in there is the right people. And if they feel that the board is not doing well, then get a new board in. You got two choices within the year that you can do. The elections, which is once a year, and the recall can be done at any point in time in that year, as long as it's not 60 days before the election or 60 days after the election. That's the only requirement. But you can do a recall at any point in time.
Okay, what if in the
Well, no, 50, it's usually a majority. Usually it's a majority, which is 51 plus 1. I know, if you have a building of 400, 500 units, that's a lot of people to come in through. Just let's go.
We all recognize as unit owners how difficult the recall process really
Yes.
is. So, just statistically speaking, how many recalls are really, out out of the number of recalls that your office sees, how many really succeed?
We don't actually see them because they go to arbitration. The arbitrator is actually the ones that settle a recall if it's not done properly, or let's say, for instance, you know, as I said before, it's a very rigorous. You have to have this form. If you're recalling the majority of the board, you have to replace them with other members. If you're recalling the minority, then you don't have to place them. The remaining board members will do that. But then once you serve that recall, the board has 5 days to have that meeting. And at that meeting, they have to either certify the recall or say, no, we don't agree with this. We're not going to accept it. And that's when they have to open a case with the arbitrator. And the arbitration department makes the decision whether that recall is valid or not. The hardest part is getting the signatures.
And how many recalls do you think happen on a
we don't
yearly
see them
basis?
because they don't come through us.
But you have an idea the
there's
arbitration.
There's a lot.
A lot of recalls happen.
There's a lot of people do recalls, especially, as I said, nowadays things are getting a little better in a sense, but 2-3 years ago, recalls were going through a lot because boards were not fulfilling their duties. We're not doing what was right, and people were complaining and all that, and you have a right. You put them in, you take them out. It's as simple as that. And you can do it again at a recall or on the election. My suggestion is always, if you're closer to your election, wait for your election. You know, campaign, put your name in. And that happens all the time. You know, I haven't asked the gentleman, but if I ask him, oh, you want to be on the board? He's going to tell me, no, I don't want to be on the board. That's too much research. You know, so, you know, and it happens all the time because I ask people all the time when they call me to complain, well, why aren't you on the board? Oh, I don't want the headaches. I don't want the hassle. That's just crazy people. I don't want to do that. That's why people continue on and on and on. So you have a responsibility. You can do things, but it has to be unified too. And as I say, in unification, it's when you're going to get things done. When you talk to other unit owners, when you present the issues, you know, the city may come in and look at those things and cite violations, fines. Now you got a city fine that you have to, you know, deal with. So there's a lot of things that have to be involved in that situation. Well, yeah. Well, no, OSHA doesn't, no. Yeah, but that's the city and the zoning is basically what really should be involved.
But in getting back to the question about being a manager and a member on the board, if the documentation says that no member on the board shall collect a salary. So
he's not collecting it as a member, it's a board member. He's collecting it as a manager. He's not collecting it as a board member. Yes, he can be both, but he's not collecting it as the president or vice president or whatever he is. He's collecting it for a service that he does. I'll give another sample of that is a board member and he has a landscaping contract. Yeah. And the contract was given to the, you know, the association gave him the contract. He's not getting paid to be a president. He's getting paid to cut the grass. So those are the difference in that. He's not getting paid to be on the board.
Someone mentioned this to me, maybe you can clarify it for me. Is there any rule or regulation whereas English needs to be spoken in the office of an association or one language? Let me put it to you that way.
No.
No, okay.
No, here may not be a problem. You go into that problem when you go further south. You got a lot of buildings that are 90% Hispanics. And if they want to do the meetings in Spanish, that's fine. If they want to do them in English, that's fine as well. We can come in and adjudicate and say, you know, English is the speaking language of the U.S. You know. You can bring an interpreter. You can ask the association to provide you with, you know, and kind of. I do things in Spanish, you know. It's their responsibility. It's their responsibility. The board's responsibility is if you're having a meeting, to conduct a meeting in English.
But I'm just talking about generally in the office, if somebody's sitting there and they're a board member and they don't know what the other two people are saying to each other, if they don't understand.
That's in.
Okay.
My mother used to say that to me all the time. You speak English because I don't understand you, and I know you're talking about me. I may have gotten in trouble, I may have gotten a slap, but it was true. Me and my sister, they wanted to know what we were talking about. So that doesn't, you know, but that doesn't constituted situation in that sense, you know? I don't know what time you want to go
We're going to wrap
through.
up soon. You've spoken very comprehensively about the jurisdiction that the Bureau of Compliance has.
Right.
Maybe you can touch upon what jurisdiction the Division of Condominium has in terms of a 718-1255 arbitration, what they do in terms of arbitrating disputes, and what other avenues unit owners have in terms of arbitration.
Arbitration will only handle certain things, and I don't have the book in front of me, but it tells you, I think it's, let me see, do anybody? Yeah, 1255, it'll tell you what actual arbitration would handle. Aside from that, like I said, what the division has jurisdiction, what arbitration has jurisdiction, your other thing is an attorney, a civil matter, you can take it to the civil court, but that's basically it. It'll tell you, I can't remember exactly what disputes are, and I don't want to make them up, but they're there. It'll tell you exactly what they will handle.
The concept is that the Bureau of Compliance can obviously enforce and investigate complaints and so forth of those three topics, but in terms of arbitration, they would adjudicate disputes, disagreements regarding the authority of the directors, to require a unit owner to take action, to regarding the alteration of or additions to the common areas or common elements, or the failure, as you mentioned, to conduct a proper election. So recalls really fall under the basket of arbitration.
Yeah, arbitration will look, and the funny part about that when you send it to arbitration, the only thing arbitration is going to look, it's that record is valid, that the signatures are unit owners, and then they're done correctly. The reason for the recall, because what the statute says, any board member can be recalled with or without reason. There's no reason needed. If you want to do a recall because you just want to get rid of that person, you can do so, and there's no justification that needs to be done. So basically, what arbitration is going to look when you send a recall petition up to arbitration, it's that it's done correctly. That you got the signatures of the unit owners are the ones that sign, and that you got the percentage. That's all they're going to look at. If everything is according to record, they're going to say very easily that recall is effective. You got 5 days to get off the board.
But the point is that certain disputes can be handled in a cost-effective manner in an arbitration through the Division of Condominiums without having to go through the court system.
No.
Certain
And
disputes.
we sometimes will refer it to arbitration. We sometimes, when we have a really dispute, as far as what you were saying, we'll go ahead and say, well, here, you file an arbitration case, here's the information, forward this to the arbitrator. So we will do that as well. I think the gentleman had,
And just one more point towards the issue of, I think you were asking whether the city, has any jurisdiction to enforce the condominium, declaration of condominium bylaws regarding multiple, consecutive rentals of condominium units. Unfortunately, the city does not have jurisdiction in that area. So if there's a building where the condo documents specify how many times you can rent out a condominium unit per year, and if there are people who are violating that, that's outside of the city's jurisdiction, and, the recourse in that situation would be through the court of law, through hiring a private attorney, but the city would not be involved in a situation like that.
There's a lot of things that could come into play with that as well, and we didn't talk about the whole situation. If your insurance company gets a whiff of what's going on, that policy is going to change. And let me tell you, it's going to cost triple the amount because it's a residential going to a commercial. So there's a lot of things that can play into all of that situation. But again, that's not something that's probably...
Okay.
Right.
We got two last questions.
Yeah.
So hang on 1 second. Let me get to these two people, and then we got to finish up.
Thank you. Appreciate that. I believe you said that your department will handle issues or investigation around financials.
Anything to do with the financial department.
Could you give me Could you give me some examples of what precipitates your getting involved in that investigation?
Improper budget, if it's not done properly, if your reserves is not done correctly, if
Who
the
would know
waiving
that?
of reserves is done incorrectly.
How would a unit owner know that?
Well, in your budget, and again, this is all in the statute, but in your budget, what the statute says, it's specifically in your budget, it must include a financial, reserve schedule. If your budget doesn't include that, then that's a violation. I do presentations about budgets and reserves, which is always, a big thing also. If the dates are incorrect, if there is inconsistency in the line items, if your financial statement is not done timely, where, like I said, it has to be done within 90 to 120 days. If the special assessment was passed, and I'll give you an example, everybody, even the 1 bedroom, 2 bedrooms, or 3 bedrooms, the special assessment was passed and everybody got passed the same amount, $100 per person or per unit. That may be a violation because your documents specify the special assessment has to be done according to your maintenance fees. So if you pay different than the 3-bedroom one, then that special assessment has to be done the same way. If the special assessment doesn't have the correct components or what it was that special assessment is for. If you look at the bank records and you see checks made out to cash or checks made out to the president, that's an improper use of funds. If you see charges to the credit card of the association for personal gain for any of the board members, that's something that we will look also again. So anything to do with financial and money, we can look into it. And when it comes to that, like I said, it's pretty much everything that we'll look into.
What evidence do you need from the person who puts in that?
Depends on what it is. If we're talking about financial statements, if you didn't get them, there's no evidence required. But if you say, well, I looked at my, I did a record request and I looked at, a year's worth of bank statements, and there's a lot of irregularities in those bank statements with checks made out to blank, checks made out to the president, checks made out for this and that. Bring us the bank statements. We don't need the checks. Normally they're in the back anyway, but bring us the bank statements. In your complaint, attach that. If it's something that you found in the budget, attach your budget. If it's something with the special assessment notice, attach your special assessment. There's some things that we don't require evidence, because if you didn't get them, you didn't get them. Like, let's say, my association hasn't done an election, and the election was due in March. Okay, that's something we don't need evidence. We're going to investigate without it. But if it's something to do where you looked at something and you saw something, send that in. And that's the evidence that we will require. We'll contact the association, okay? We'll contact the association, and we'll ask the association also to provide us documents. So that's how the whole process starts.
On behalf of the advisory committee and the city, we'd like to thank very much for a great, lively, very informative presentation.
Thank you.
Thank you.
Budgets and reserves, financial statements, those are all presentations.
So we'd like to call this meeting to a close, but if anybody wants to raise their hands, if they're interested in additional, maybe another discussion or seminar about things of this nature, just.
I have all types of presentations that I can definitely.
Thank you, everybody, for attending.
Thank you.
Thank you so much,
Thank you.
Lazaro. Great job.
That was cute.